and welcome back to the One Take Show podcast. In this episode, we are in conversation with a very, very special guest. Our guest today is Jurist Dr. Srikant Parthasarathy. Dr. Parthasarathy is the founder of Chambers of Dr. Srikant Parthasarathy and door tenant at Holborn Chambers in London. He is also the alumnus of the Hague Academy of International Law, that is Hague Peace Palace. He is a panelist at 34 International Arbitral Institutions of prominence, and he is a recipient of President's Award for PhD in Investment and Finance Law, one of the very few supporting members from India of the top 5 maritime arbitration organizations of the world. He is the International Arbitral Counsel for Forbes 500, family advisor and chief legal and finance officer with 15 years of experience in arbitration, cross-border mergers and acquisitions, corporate finance, treasury, fundraising, etc. He has previously worked as a venture partner and finance champion with experience in hand-holding the entire finance function, handled investments over 100 million US dollars in India, Southeast Asia, and in areas of QSR, technology infrastructure, education, etc. He is an expert for the European Commission. He is the visiting professor for national law schools. He is the fellow of Asian Institute of Alternative Dispute Resolution. He is the CPR Distinguished Neutral and Arbitrator, member at International Bar Association, panelist at Delos Dispute Resolution. He is a mentor for Niti Aayog, supporting member for Hong Kong Maritime Arbitration. He is a panel member for German arbitrations, and he has represented India in the World Space Law. He has been a visiting professor for IIM Indore. He is a member of Gujarat Maritime Cluster. He's been the member of International Council of Arbitration. He's a member for Young Singapore International Arbitration Center, and he has been a technical arbitrator for Internet Dispute Resolution Center, that is IDRC. He has been a visiting professor for various law schools and various management schools such as the Nasi Muji School or SP Jain School or various other such institutions inside our country. And in totality, he brings to this episode one of the finest, most rich, most vibrant experiences and perhaps the most interesting conversations that one could ask for. Well, if you like this episode, make sure you like, share and subscribe to the channel. If you have any suggestions or feedbacks, write them down in the comment section. I would love to read them. It's ladies and gentlemen, without further ado, let's start with the podcast.
You want something, go get it. Period.
All right, so we are recording. Hello, sir. Welcome to the One Take Show. I am so excited and so honored to have this incredible opportunity. I still remember we were competing for the FDI moot, both regional rounds as well as the global rounds, and I had the opportunity to run into you, to be adjudicated by you, to present my case in front of you, and it was absolutely blissful. I think your journey with law, your journey as a part of your career, has become an example for anyone who wants to either follow your path and also to create their own niche in this industry, to understand what are the possibilities that can be explored. So thank you so much for taking time off your very busy schedule and sitting down with me for this conversation.
It is indeed my pleasure to give back to the to the student community, I would say. I clearly recall the conversation that we had during the FDI moot. And it was one of those probing questions that I had insofar as the problem of that particular year is concerned. And I had been particularly quite chatty, I would say, in mooting experience, I would say. Primarily because of the fact that I would like to get the best sort of a particular candidate or a particular participant who is participating. And the reason why I choose Mooting as a platform to engage with the future of today, and the ones who would replace me perhaps in the future, is to make them more agile and more inviting to discussions and to perhaps questions, I would say. As we speak, I am going to be in the FDI moot of this year. And we had a new moot which was being formulated. I wouldn't say new to India as such, but a new moot that I was perhaps participating, which is called the mediation moot, which is the FDI state investor mediation moot. I would strongly urge the viewers of your channel to participate in it. With that being said, my initial and foremost thanks to you, Kaustubh, to have made this possible and to help me share the journey so far. I started my journey in 2007, and as we speak, I spoke the same at a similar event, and where I was sharing the journey with about 2,400 students in person, and this was an auditorium which was brimming, and people were trying to get into the auditorium. It was quite a big auditorium. I wouldn't want to name the name of the university unless until the video comes up of the conversation. But that being said, starting my journey back in 2007, the world was going through a lot of crisis, much like the crisis that we are going through right now. And that was a financial crisis that the world was going through. There was meltdown that was happening, and with meltdown comes a lot of litigation, much like we saw in 2008, 2010, and perhaps in 2013 with the war, and in 2015, when 15-16, when the decision of Brexit actually happened, which fructified into a decision in 2020. So the world has been through very, very turbulent times, and with turbulent times comes the need for councils and the need for knowledge to step in to make some sense out of this conflict. And as we speak today, the world is going through a lot of conflict and a lot of challenges in terms of sanctions, in terms of proceedings in the International Court of Justice, in terms of opinio juris, and so on and so forth. So I would strongly urge any viewer of this particular channel to particularly delve into the crisis that we are living in and to draw parallels to the crises that we have been in the past, because that is what shaped me to address the point of where I started. And in 2007, it was literally, we did not know the financial law, and arbitration as it stands today did not exist in the most advanced forms, or not talked about as vehemently as it was talked about right now in the past 1 year in 2007. So we started off with templates, and we started off with financial transactions mandated by certain central governments or central banks. At those points, we used to call it the ISDA contracts. And those ISDA contracts had those inherent complexities of moving away from a templatized version of a contract versus setting your own templates, and the litigation that followed thereafter. It slowly led me toward non-standardized mechanisms of contractual arrangements, which led me to a lot of, I would say, startups, which kept me in Bangalore for some time, because Bangalore was the hub of startups. And those were the times when Swiggy used to be called, Swiggy is still called Bundle Technologies, but Swiggy was better known as Bundle Technologies. And then we had a series of companies which were operating from a small nook, and they were looking at possible investments. And that gave birth to a whole lot of complexities, primarily because of the fact that international companies wanted to invest in India, and there was a boom in the market. In 2015, I started a fund which was investing in companies, and then I was also acting as a legal counsel for various companies in terms of managing the fund and in terms of helping family offices and so on and so forth. So the journey has been through a lot of turbulence. So with turbulence arises work, and with work arises knowledge, and then the whole cycle repeats. So with knowledge arises turbulence, and so on and so forth. So if one were to I were to perhaps summarize the entire 15 years into one story, that would be the macro level conflicts slash turbulence slash uh, pointers which are leading the legal profession in a particular direction. And as we stand today, the law has undergone a lot of change, and new laws are being introduced. The last I checked, 17 laws were introduced in the parliament in the last session. Uh, Amongst them is a criminal bill. Amongst them is the Antarctic bill, and amongst them is a bill to regulate the geographic contours of certain territories that we have. So to me, the youngsters of today should read up quite a bit on the latest events that are happening on the parliamentary side, on the legislative side, to look at how drafting happens. So, to me, the great point of pivot for a young counsel who would like to venture into this particular, or rather would like to become the name to be recalled, a name to be reckoned with, is to branch out of the seniors direction and venture on their own. So as a matter of fact, as we speak, I have 5 research assistants who help me in terms of formulating certain legislative policies of 4 island countries, and we have drafted the law of arbitration of 4 island countries, and that is a phenomenal task that could be handed down to um, a assistant who's basically writing the law of a country. And imagine that's the highest position that you can perhaps get after being a democratically elected person of a particular country. So that has been my journey, and I have always furthered my interest in research, which led me to perhaps the Hague Academy, and then pursuing my PhD. And as we speak today, I am advising the European Commission on certain matters, including the legislative framework, and advising on the TFEU. So my journey has been through a lot of geopolitical action which is going on in terms of various countries, various organizations, and various I would say treaties which are binding countries together, and the same treaties which are letting the countries separate from each other. So that has been a large part of the work, and the young counsels of today must look at courts or legislative systems outside India to get a hold of what comparative legislature looks like, and perhaps a good point of conversation, or a good point of indication of legislation would be, I wouldn't say a good point, but let me rephrase that. A good thought about a legislation is how the Arbitration Act is a mere representation of the UNCITRAL, and we have many countries actually signing up for the UNCITRAL model. A funny fact that we would like to I would like to give you the ICC CPR. The ICCPR was initiated in 1966, but our constitution was born in 1950, and the ICCPR Article 19 is a mere representation of what we have in Article 19 in India in the constitution. So imagine the level of reach that the Indian constitution has had over there, and the level of reach that particular legislation has had over here. So apologies for being a little overly, I would say, overly essayistic in my answer. But to me, the legal profession is such that you have to think beyond the answer that you intend to give, it's never a yes or no or a binary answer, in my opinion at least, to give you an answer to any particular situation, including the journey of a particular individual.
Right, right. Because there are a lot of such inputs in this answer that I would love to explore. Apart from the fact that there is definitely intersectionality that I would like to explore, especially when it comes to international law and the kind of evolution that we're observing. And from a student's limited point of view, which is usually and majoritarily the viewer base of my podcast, where we try to understand how international law is a sphere where we can either explore or how can we participate as students. And you pointed out that your research assistants are not just participating but are key factors sort of in your while assisting you, the key factors while formulating, let's say, arbitration laws for certain countries. And that in itself is a testament to how important such legal education or legal exploration can be for a law student's life. But if I were to break it down and sort of bring a couple of points clear, because I would love to have some sort of clarification on some points that you mentioned, because I think they're very important. uh, I think with the career that you've had with respect to this exploration of a study, of a research, of a constant engagement with such legal study, must have started at some point of time in your law school, because every law student, as what I have experienced as well, in law school does not always find a clear cut answer that this is okay, this is something that I want to do, or this is where I want to spend the next 10, 15, 20 years of my life on the get go, especially when you point out that in times of crisis, there is obviously a response that is required from the industry entrants, especially the aspirants who are just about to enter the industry. So, if you could identify that one point of time in your educational background where you could point out that okay, this is the point where I realized that this is the area that I wanted to enter into, and this is the kind of research that I wanted to undertake. And what was that realization like? What were the factors that helped you sort of facilitate that realization into actual tangible work as well as the output of that work?
So to be very honest, Kaustubh, I think I did not quite have a realization per se, but I had a point during my educational life, and I would consider myself to be a student even now. So your viewer is me as well, because I'm a student. Everyone is a student for life, in my opinion, at least. So to me, the realization was when I saw this big a book on, I would say, corporate law. My friends, what are the limited friends that I had at that particular point of time, found it very difficult to comprehend corporate law. And it was mixed with SEBI laws, and it was mixed with financial laws, including international law. They had a very mixed feeling about it. And when I say mixed feeling, it was mostly a mixed feeling of feeling neutral and feeling bad. So that's a different kind of mixed, not the good and the bad. It was a neutral and bad. To me, it was never a mixed feeling. It was I could I could perhaps interpret the book in a manner that would stay within the book, and stay and perhaps even add on to the book in terms of what could be the um, potential law slash potential case which is out there, which is relatable to that particular knowledge of area that I'm studying. So perhaps to me, when I pick up, let's say, there's a book which is lying around. So this book, which is a ICLR, to me, when I pick up a book, it doesn't feel like the words are being written. It feels like I get myself into the shoe of the person who has particularly written this particular judgment, and so on and so forth. I believe this is the point of reckoning that I had 16 years back. No, even before that. This would be 18, 19 years back. So I think it wasn't a point. It wasn't a juncture that I could put a pin on and say that this is wow. This is an area which I like. This is an area where I want to pursue. It just happened to be an area where I excelled, and I really liked reading law. and especially the residual part of a legislature. And that is something that I love to read. So there used to be this. So how a law is structured. A law is structured by commencement, title, then you've got the body, then you've got the residual pieces in terms of the power to enact and so on and so forth, and then the repealing provision. To me, it felt like I could perhaps draft a law, and that is what led me towards commenting on law. And that is when in 2007 I commented on the Make in India policy, or the India manufacturing policy, or the India 5-year plan that we had at that particular point of time. I made a comment on it, and it exploded like a bomb. It's fairly researchable, so please do your online research in terms of what I had written. And it went on to become quite big. And in a day or so, it was a if I may be honest with you, Kaustubh, it was this was something which I was reading on the way from, and I clearly remember where I was reading this. I was reading this from on my way from Hyderabad, when I was traveling from Hyderabad to Bangalore. And this was the time when I didn't catch a flight. I took the miserable route of taking a bus, and it was 11-12 hour journey, and I didn't have anything to do. And this was a time when you didn't have phones to you didn't have YouTube and whatnot to actually listen to podcasts and so on and so forth. So the only way that you can while away your time is by carrying a book. And I happen to carry the India. It is nerdy as it may sound. I happen to carry the India 5-year plan. I don't know why I carried it, but I just carried it. And I was looking at it. I was circling. I clearly remember I took a pencil and I was circling every bit of what was written over there, and I started thinking about what to write. I reached Bangalore, and I pulled out my Word 2007 edition. I clearly remember that, because there was a 7 edition, and then 10 edition, 13, and then 17, and then now we have what now 365. So I'm just being a little nostalgic over here. But I typed it out, and it was done in a day. And the next day, it got published. And the day after, without even my knowledge, there were scholars who were commenting, who were commenting on Srikant Parthasarathy explores India entry strategy, and there were commentaries on it. So imagine being in your early career, and with the paper just taking you to a different direction. And I received phone calls after phone calls. Those were the times when Truecaller was not there, so I had to literally pick up every phone call, because you didn't know who was calling. And the phone was ringing non-stop. That is when I realized that drafting is perhaps my piece of is perhaps something that I would perhaps do. So I had three opportunities, I would say. One is to enter the civil services and get into the thick of drafting, which I did in 2009. I cleared the prelims, and then I cleared myself to the mains. Unfortunately, I wasn't able to clear the mains twice, but twice I cleared the prelims. So I perhaps left the choice of civil services. Then I had another choice, which is to become a politician. I wasn't. I lacked the knowledge of the local language summarily enough to actually become a politician. So I wouldn't have stood a chance. I hope I stand a chance right now by your podcast. Hope this explodes, and I am able to be a politician now. However, I did not desire to. The third was to make my own comment on legislation, and which is something that I did, which is far more accessible, and which is something which is more democratic, which everyone can do. So that is where I started, and perhaps that is what I would advise your viewers who are students. students, as in people who are fairly gray textured in their hair, who are also students, to actively consider legislation as a piece of uh, work in progress that they could comment on.
Right. I mean, if of course, like if this episode at all does end up in a position of you becoming a politician, I think that would be just as great of an achievement on my part, it, as it was for your commenting on that piece of legislation. But primarily, I think this is a very interesting conversation and a very unique outlook towards someone exploring their career fields, especially when it comes to finding that level of passion, understanding towards legislation. You've previously mentioned that you find great pleasure in researching, even till today, you still find great pleasure in drafting, and that studying legislation is something that interests you a lot. This is something that I've found slightly missing as a discourse amongst law schools. Like for now, what I understand is that majority of the law students have to talk about recruitment, which I understand is fine. Like it's also required in the times which we live in, but there is a slight missing conversation or a discourse that surrounds that level of intellectual engagement. But for the people who genuinely want to explore this, for the people who are into academia, want to research, want to find that nuanced understanding of reading into the law, reading into the text, as you mentioned, filling the shoes of the drafters of the legislation. What advice would you have, and what were the major challenges that you faced while you were sort of building these skills as the set that would aid you while you were trying to perform either in your job or while as a researcher or while finding opportunities?
So I think I rolled this into the introduction which I gave you. I believe there is a lot of subservience in the system, which makes a unique candidate to not be able to think outside the box, for a lack of a better phrase, primarily because of the fact that there is question of seniority in in the the field that we are in, and this runs by the level of seniority, and I think that is something that has to be done away with, primarily because of the fact that we cannot be questioning knowledge, or rather we cannot be equating knowledge with seniority. That is not how the brain functions, or that is not how sociology or cognitive psychology actually works. There may be a correlation, but it's not necessarily true. When I was a rather younger self, I made a disruptive attempt at legislation. It succeeded, but it was something that I kept under the wraps. I did not disclose it to anyone. I did not, perhaps I made a very wise choice of not sharing it with anyone, because if I had shared it with anyone, all I would have received, and I'm fairly certain that this would have been the case, the advice that I would have received is, you are too dash young to do this. As simple as that. You cannot be doing that. So that would have put me off. It would have put it would put anyone off. I believe the students of today should make a very wise choice of taking certain decisions of research independently. They should not be falling back on advice can be sought as to the direction, but whether to start or not a research should be primarily done independently. I don't think that should be left to the discretion or advice to others. That is number one. Number two is with regard to recruitment. With regard to recruitment, I think with law schools having moot courts, and then moot courts having I participate in a lot of moots, and then even in moots is something. This is something that I tell the participants, is to think of original arguments on the fly and not look at rehearsed arguments to perhaps put out to a particular judge in terms of what they would like to do. So I do not believe in rehearsals. Rehearsals is something that students should do away with. In terms of law schools, I would strongly urge you to go beyond the syllabus which is there in the law school and to research areas which are not there. For example, the marine ecology is so unique that I'm sure even the top law school in India, and I'm liberty to say this, even the top law school in India does not quite teach you in their basic syllabus. So this is something that if you are interested in maritime law and the law of perhaps the marine ecology and the protection of ecology, protection of and whatnot of so and so is something that you should be looking at. So I think there is a lot of mechanical work which is happening, which is the research output that you as a candidate is giving out just for the brownie points of settling in a comfortable job which would very well not be within their domain of what they've written. I think where the engagement really cuts off is after graduating from a law school. You enter being an associate, you work 18 hours a day, which I vehemently oppose. But assuming that you work 15, 16 hours a day, there's a lot of work that you're on board. Of course, social life is definitely needed, but I would pencil about 30 minutes of time every day to just write on something, to just explore on a topic that they like, that they are passionate about. And that 30 minutes would be an investment for your future. And I'm not asking you to sacrifice on your work. I'm telling you after the work is done. So you need not think about work all the time. Just start off with not 30 minutes, let's say 15 minutes a day. It adds up. And 15 minutes a day just on something that they like is something that I would advise students to do. And all the more for the students who are in law schools, because I know, you are definitely not putting out 15, 16 hours a day in studies. You may very well be, but it may be during a limited duration. It may not be continuous 15, 16 hours. So perhaps pencil 30 minutes out every day on something that you are passionate about. Finding the thing that you are passionate about itself is a journey. And that 15 minutes of individual. So speak to yourself. Don't speak to anyone else. Just ask yourself what you like. And do not be influenced by so and so said this is a career that we need to pursue. So and so said that this is a area which is booming. Perhaps I should research in that particular area. No, don't do that. Research on an area that you genuinely like, genuinely are persuaded by, and that is an advice that I would give law schools and law students. And law schools should be adaptive in terms of I teach in the top 5 law schools in India, and law school should be, at least in my class, I teach them to be adaptive and to explore a area of law that they have unheard of. India passed something called the India Antarctic Bill. A lot of us did not quite know what the Antarctic Bill was, as to why we are passing the Antarctic Bill. This should have been passed in 1963. We passed it in 2023. As a matter of fact, I've written about it in the Hindustan Times. So that is something that a student of law at whatever stage of gray in your hair maybe should actively be looking upon.
Right. So, because I think there's so much to unpack from just this segment of the conversation. Number one being that what I understand as a juxtaposition to whatever the status quo is, that people usually engage with research or engage with let's say writing, for example, or activities, especially in law school, for a definite motive of tangibly converting it into something that can land them a job. I don't believe that majority narrative or the major narrative with respect to the study of law, at least in the law schools that I'm familiar with, is that there is a genuine curiosity with respect to a unique area of law that could be undertaken as a study, undertaken as a research, and different unique outputs can be brought about. But what you're suggesting is very unique. You even mentioned that you also judge moots, and this is definitely what I wanted to ask you about, because also from a very selfish point of view, because I've also experienced that. But I think a lot of law students who sit for moots, and in my opinion, mooting is one of the most celebrated exercise one can undertake in a law school. It generally awards a lot of experience, especially with respect to the skill set, made be research, arguing, presenting, and as you mentioned recently, free thinking, thinking on your feet, especially when you are not giving out rehearsed answers, but giving out the answers which are original, something that you can adapt to at that moment. So, from that perspective, I think if you could tell me a little bit about what is it in a law student that you see is important, especially let's take the context of mooting, that you would really appreciate if a law student does when it comes to formulating of arguments. Is it primarily the research base, or is it the ability to have a logical, deductive conversation with a judge where you could simplify the factual situation and can have a conversation around it? Or is it a synergy of both these facts, the research as well as the factual matrix that is provided to everyone? Is there any such factor that really stands out for you when you're adjudicating such moots?
Because we must have faced this. I ask a lot of questions, and I ask questions to the point that the candidate or the participant actually flips to me after on off camera. So gladly it was an online event, and off camera they flip me a good one after the moot. I'm considered to be quite uh, not heavy, but quite headache to bear with, I would say. So the reason why I do so, and this is something that I would like to share very personally with the viewers of your channel, is I would like them to tell me through research and through the analysis that they have done that I am dash wrong and I need to take a hike, not in so many words, but through the research. And you cannot do a flip during the mooting exercise by saying, Srikant, shut up. But you need to tell me to shut up by the research that you have done. And that is something that I look forward in. That is what I push them to. And this is what I've been pushing participants in the JESUP, which concluded recently, where I was in the global global round of 8, and it is quite a sad scenario that from India we were not in the round of 8, if I'm not wrong. But this is what I push them to. The level of diplomacy that they use. Of course, I'm not a good example of diplomacy in this conversation, at least. The level of diplomacy that they use in telling me to take a hike through research is something that I actually look forward to. And it gives me immense pleasure when one or two teams which have actually done that, they do that. And I tell them on their face after the moot that, look, you told me to take a hike. I really liked it. And there's a lot of, I would say, negative perception, which is there in the mooting exercise, I would say, where they are, again, it points back to the subservience, which I was referring to. And this particular subservience is something that they're quite subservient to the judge because they are going to award the points. But I'm speaking only for myself. The other, I would say, judges may not be like me, but I like it when they flip one off to me through research.
So I think this is very, very interesting. I'm very excited to hear that answer because I had a senior who used to guide me in my initial years of mooting in law school. He used to tell me you should have that one shut up answer uh, to every major issue that you're dealing with. So that if the questions or the grilling goes to a certain point, you should have that one shut up answer. You should have that one direct answer. Stop meandering around with unnecessary explanations, but just come to one point of answer that really changes the tide of that conversation. But this is very exciting. I'm sure like this might not apply to all the judges and definitely might not work with every round. But what my experience was that when I was arguing before you, the questions were so engaging that I had so much fun simply having the conversation because there was a level of understanding with respect to what I wanted to convey and what was actually getting conveyed to you as well. So that was absolutely wonderful. From that standpoint, I think since we've had, you've mentioned that you've judged Jessup as well, and obviously Wiz, and then there is FDI. Do you think that this level of engagement with respect of the international law in general, is a sign that law schools or law students today have started exploring an area which was usually something that we might not have explored in the past? And is it a good exercise for us to purposefully look for such areas of laws in international law that could provide us with opportunities which might not be necessarily available in India? Primarily because if we look at ISDS practice, might not be very prevalent in India, are limited to a couple of law firms or the teams that practice ISDS. But when we look at countries like London or Singapore, they have a very vibrant practice when it comes to ICA or ISDS, for example. Do you think this is a good exercise for our legal industry in general to engage with this kind of a conversation or study or law students participating in moots like these?
So but I hate to break it to you, Gaurav. So I think the mooting as a concept or international law or heavy mooting, or when I say heavy mooting, moots which are difficult, which are not your writ petitions. And I'm not saying writ petition is quite a not so challenging thing, but a little difficult and little more advanced, a little more technical issue like the exit or perhaps the ISDS investor state, just like I mentioned, FDI mediation mode. I think unfortunately, Kaustubh, India is witnessing a handful of schools amongst the the pool of schools that we have in India, which is being represented in these moots, which is very, very unfortunate. Primarily because of the fact that I have interviewed quite a few candidates from law schools, which I would not want to name, but they have not heard of these moots. They've absolutely not heard of certain heavy moots which happen. So to me, the level of engagement in the mooting community is definitely a yes, but it should also be inclusive. It should also include all the law schools which are perhaps engaging in the mooting exercise. And second is, I feel that the mooters who have mooted in these moot courts should go out there and canvas, of course, not being a commercial canvas or a commercial proposition, but to engage the next generation of perhaps mooters who have not even heard of this particular moot, to explain to them as to what this moot is about and how difficult this moot was and what were the nuances of this particular moot and why is it difficult in the first place and why they should participate is something that I would want the the law schools of or the law graduates to actually do. Secondly, the reason why we have only a handful of practitioners of ISDS cases in India is because of the sheer technicality of it. It requires a lot of research, and that points back to the conundrum that we were talking about a while ago, which is the research which is out there in ISDS. If you would like to pursue ISDS and it genuinely interests you, is absolutely abysmal. India has severed all its BITs from 2016. And 2007 was the last time that India ever drafted its BITs. So if you're looking at BITs as a concept, and legislation is definitely, BIT is a more formalized and independent secondary form of legislation that you would find. And if this interests you, then you should be looking at the history of legislating BITs and so on and so forth. I think that is where we have lost the plot to perhaps jurisdictions which are outside India, primarily because of the fact that, not because we lack uh, the understanding of it, but because of the fact that we lack the appreciation of understanding of it.
Right, sir. Because I remember having a conversation with another wonderful guest I've had on this podcast, and Mr. Yamarur, and he engages directly with the ISJS, and he was telling me how, like, there are different reasons. Obviously, there are different contexts to why the BITs today, for example, are slightly restrictive from India's side, and for all the various reasons that there are. For example, treatment clauses not being very rampantly present in most of the FTAs that are being signed, and all of those various different instances irrespectively has an effect on the legal practice that exists inside a country. And I think that effect necessarily translates into what kind of opportunities are available to the law students who have to be either by the limited privilege that they have to stay inside India and to practice inside India, or to irrespectively work in a particular law firm for all the other reasons, have a limited area of practice to explore. But I think this is an interesting conversation, especially from your perspective, because as you mentioned, you have also been engaging with pedagogy. You've engaged with students on as a faculty member. You've engaged with them from a pure academic perspective as well. Uh, if we are to talk about the environment that surrounds, and you mentioned that law schools in general have a slight disparity. That's a certain class of law schools that have all the exposure and opportunities, whereas there are other law schools which might not have the equal amount of exposure. As a faculty, as a professor, as a teacher, as an academician, or as someone who's guiding law students, engaging with them at an academic level on a very regular basis, do you see there is, if any, evolution happening, or if there is a requirement of an evolution, and if there is at all a change that is required? Could you pinpoint any particular change in the way our pedagogy works that we can somehow make our law schools a little more useful from that perspective?
I think the question of pedagogy starts with the professor. And I think the viewers, this is pointing to the fellow professors of mine. You should be drafting syllabuses which are open-ended and which allow the participants to to explore outside the syllabus. There's nothing called a syllabus in law. Let me be very clear about it. There is a context. There is a context of perhaps international law, and there is a context of perhaps international arbitration, but now there's nothing called syllabus of international arbitration. I think the question of syllabus has to be done away with. uh, of course, this is something that I would I would not want to comment on the NAP, but I think the law professors have, at least in most universities which are autonomously run, or at least in a handful of universities which are autonomously run, should be drafting the syllabuses in such a manner that it gives a lot of ample it gives a lot of room and ample opportunity for a participant to explore the different contours of interpreting the context. And interpreting context is all about vehemently searching for research outside the area that you're comfortable with. And I do not want to square it out or box it out to a particular silo, because the moment you start creating silos, I mean, again, I'm using a metaphor over here. There are different kind of silos, and the silos that we create, which is typically an area specialization that we do, may very well be a jail bar, the bars that we have in a jail. So silo could be a good thing and silo could be a bad thing. You don't want those silos that you create for yourself to be actually a jail for the knowledge, or a restraint on the knowledge that you intend to acquire. So perhaps this is addressed to my fellow professors and to the students. I wouldn't dare to say that you go outside the syllabus, but at least ask as to what you could do outside the syllabus. And like I said previously, you have 12 hours of engagement with the class, 12 hours of engagement in academic circles. Perhaps explore 15 minutes a day, 20 minutes a day outside that academic, and fly it by a professor. And if you would like to fly it by me, more than happy to. I respond to every email, and I respond to every text which I receive. So more than happy to comment on it, because I'm passionate about students furthering their knowledge.
Right, sir. Right. I think this allows for perhaps a very interesting opportunity for all the law students because, as you mentioned, right, there is definitely a requirement with respect to overhauling the way we look at the legal studies. For example, we all the law students. This might sound very naive. I understand coming from a law student, but we've all had a contracts law subject as a semester subject. We all studied for that. But subsequently, in my last semester, we started studying the economic theory, the law and economic theory of contracts and everything. And then we realized that perhaps we should have been taught the economic theory of contract and the bargaining theory of contract while we were being taught Contracts Act in order to perhaps have a better understanding of how it was approached. Because at that point of time, we only looked at Contracts Act from the perspective of the sections that were involved and the case laws that existed. And I'm sure like that was also useful. But in my opinion, could have been a little more of a discourse, could have been slightly more rich if we were taught from a backdrop and not limiting it to a very strict syllabus. That's a very interesting intake. Now, I think I wouldn't really stretch this conversation too far. I think I've already taken a lot of time of yours. But my last question to you is that you've had a very, very celebrated career. You've represented our country in multiple forums. You've also researched, you've also produced a lot of material. You've guided a lot of students. What would your advice be for any student who wants to follow your footsteps? Were there any particular challenges in your life that you would like to warn a student who perhaps wants to follow your path or wants to create a career profession like yours or wants to have an identity or a brand like yours in the legal industry? And what would your suggestion be for them?
The first and foremost suggestion would be to not follow my footsteps. Follow the footsteps that you would like to take. And that is something that I have been vehemently advising all the law students, because following somebody else's footsteps is going to lead you to their goal and not to your goal. And this may sound like a motivational theory, but unless you would like to go to the same silo that the person that you're following the footstep of, then you are basically riding off the person's life. So my piece of advice to the students would be to find a meaning for law, find a meaning for what you're studying. And if you intend to be a lawyer, if you intend to be a counsel, if you intend to be someone who practices law, then I would strongly urge you to find your calling within the practice as to what exactly would motivate you to be there for life. And when I mean life, the next 40 years of your life. And 40 years is a significant portion of the life to be spent on. So find your calling. And it happens, and I'm being practical over here, it happens that the calling that you have, it could be marine ecology and the law surrounding you may very well may want to become a diplomat who legislates, I mean who signs treaties with countries. But it's not quite possible. I also wanted to be a civil servant. I also wanted to be a politician. And I hope because something happens on that line. Of course, I wouldn't want to take it up. That's a different thing. But the point I'm trying to make over here is find a calling. And that calling is something that you can do on the side. And that is something that you should be doing on a regular basis. And if you're able to do it on a daily basis, on a moment-to-moment basis, by separating your brain into two parts, one for the practical reasons as to why you may want to get into XYZ and co and practice contract and practice arbitration, practice litigation, and day in and day out you will be doing property act, you'll be doing writs and whatnot. That is your side profession. Let's be very clear about it. Your main profession is this. I mean, the side profession will earn you, so that is your side income. This is your main income, in the sense that main income that you're investing in the future toward pursuing a particular goal that you intend to pursue. So that is in no way demeaning what you are doing right now. That is in no way insult to any of these law firms who are currently who you are. If you are a viewer, you are engaged with. But it is just a piece of advice for you to follow follow the calling that you have in law. And sometimes it so happens that you realize that law is not your calling. I've seen quite a few friends who have pursued a career in law for some time, and they realized that it was not their calling, and they did this exercise of 10 minutes every day or 15 minutes every day, and they found their calling in sports. And I've found people who have done sports at 40s, they find their calling in law. So I've seen both ends of the power struggle, I would say. So find your calling. This is not something that is unique that I'm telling you, but remember that your calling pays off better than your main job.
Your calling pays off better than your main job. Wow, this could very well be the thumbnail of this episode. I could very well use this in all the different places, especially where I think this is a very interesting sort of a concept, because obviously you don't require an overhaul immediately. You can simply just invest 10, 15, half an hour every day and have that consistency bring out the fruits for any calling that you would want to explore. This has been absolutely wonderful. I'm really, really grateful for this conversation. So I could not have imagined that I would have this opportunity to speak with you, and let alone take this conversation to everyone who watches this podcast. And definitely would love to either get your guidance, either in future, would connect with you and definitely follow your guidance. I think this has been one of the best conversations I've had on this podcast. I'm really grateful once again. Do you have any closing remarks for our viewers who watch this podcast, who listen to this podcast?
I would close by saying you are lucky that Kaustubh is asking such engaging questions, because this is something that I believe you would have wanted to ask, and I believe everyone would. I think it's a collective question that any law student or any student of life would perhaps want to ask, and I would like to thank you, Kaustubh, for this engaging discussion, and to help me share a very honest and peaked view in terms of what I felt about law. And I would be looking forward to more such conversations from yours, uh, uh, and perhaps be able to guide a few students as well, if at all. And that's my calling, by the way. That's something I realize, that I'm good at perhaps guiding.
Right. So I think it goes without saying that it's been an honor for me to have this conversation, and obviously it will be an honor to host you again. I hope to have as many conversations as I can, because definitely it's a learning experience through and throughout. Thank you so much for this opportunity. I had a wonderful time. I hope you had a good time too. Thank you so much for joining me.
Thank you.
Thank you so much, sir.